All right, we're live. We're starting with Rule 13 of the Federal Rules of Civil Procedure. Interesting because we went through 1 through 13 in the first recording. Now we're going to attempt 13 through 26, which is another lucky 13. But once we reach 26, we'll be in the discovery section, which I've thoroughly note carded. And we will transition to note cards from there on out because all of the trial related and post trial related matters I've probably note carded too. It's this joinder section that's very difficult. So Rule 13, counterclaim and cross-claim. A, compulsory counterclaim. In general, a pleading must state as a counterclaim any claim that, at the time of its service, the pleader has against an opposing party if the claim A arises out of the transaction or occurrence that is the subject matter of the opposing party's claim, and B does not require adding another party over whom the court cannot acquire jurisdiction. Exceptions, the pleader need not state a claim if A, and exceptions is number 2 under compulsory counterclaims, letter A. Exceptions, the pleader need not state the claim if A, capital A, when the action is commenced, the claim was the subject of another pending action, or B, capital B, the opposing party sued on its claim by attachment or other process that did not establish personal jurisdiction over the pleader on that claim, and the pleader does not assert any counterclaim under this rule. So that's your compulsory counterclaim rule. So I'm not sure how to apply the exceptions. Just going to read the general rule again for compulsory counterclaim. A pleading must state as a counterclaim any claim that at the time of its service the pleader has against the opposing party if the claim arises out of the transaction or occurrence that is the subject matter of the opposing party's claim and does not require adding another party over whom the court cannot acquire jurisdiction. The reasons or the exceptions to the compulsory counterclaim is when an action was commenced, the claim was the subject of another pending action. That makes sense. And B, the opposing party sued on its claim by attachment or other process that did not establish personal jurisdiction over the pleader on that claim, and the pleader does not assert any counterclaim under this rule. Permissive counterclaim, this is letter B under Rule 13. A pleading may state as a counterclaim against an opposing party any claim that is not compulsory. So you're talking every claim between the parties. So every claim the plaintiff has against a defendant may permissively be joined, and it doesn't require, as letter A did in the compulsory counterclaim, it doesn't require that it arises out of a transaction or occurrence that is the subject matter of the opposing party's claim. And I'm going to leave it at that. C, letter C under Rule 13, relief sought in a counterclaim. A counterclaim need not diminish or defeat the recovery sought by the opposing party. It may request relief that exceeds in amount or differs in kind from the relief sought by the opposing party. Counterclaim against the U.S. Letter D, these rules do not expand the right to assert a counterclaim or to claim a credit against the United States or United States officer or agency. Letter E, counterclaim maturing or acquired after the pleading. A court may permit a party to file a supplemental pleading asserting a counterclaim that matured or was acquired by the party after serving an earlier pleading. F is abrogated. G is a cross-claim against a co-party. A pleading may state as a cross-claim any claim by one party against a co-party if the claim arises out of the transaction or occurrence that is the subject matter of the original action or of a counterclaim, or if the claim relates to any property that is the subject matter of the original action. The cross claim may include a claim that the co-party is or may be liable to the cross claimant for all or part of the claim asserted in the action against the cross claimant. H, joining additional parties. Rules 19 and 20 govern the addition of a person as a party to a counterclaim or cross-claim. I, separate trials, separate judgments. If the court orders separate trials under Rule 42B, it may enter judgment on a counterclaim or cross-claim under Rule 54B when it has jurisdiction to do so, even if the opposing parties' claims have been dismissed or otherwise resolved. So that's the end of Rule 13. Rule 14, third party practice. When a defending party may bring in a third party. Timing of the summons and complaint. A defending party may, as a third party plaintiff, serve a summons and complaint on a non-party who is or may be liable to it for all or part of the claim against it, but the third party plaintiff must, by a motion, obtain the court's leave if it files the third party complaint more than 14 days after serving its original answer. Third party defendant's claims and defenses. The person served with the summons and third party complaint, the third party defendant. In other words, A must assert I'm going to just read this section all over again because I really haven't been giving the citations. This is called third party practice, Rule 14 that is. Letter A is when a defending party may bring in a third party. So one is the timings of the summons and complaint. A defending party may as a third party plaintiff. Okay, so this is still a defense by the defendant, but doing this, they become the third party plaintiff. And there's a third party defendant that they are joining, right? So timing of the summons and complaint. The defending party may, as third party complainant, on a serve a summons and complaint on a non-party who is or may be liable to it for all or part of the claim against it. But the third party plaintiff, right, because the defendant turns into the third party plaintiff, must by motion obtain the court's leave if it files a third party complaint more than 14 days after serving its original answer. Third party defendant's claims and defenses. A person served with the summons and third party complaint. The third party defendant, this is number 2 under letter A, can do the following. Capital A, must assert any defense against the third party plaintiff under Rule 12. Must assert any counterclaim against the third party plaintiff under Rule 13A, and may assert any counterclaim against any third party plaintiff under Rule 13B, or any cross-claim against another third party defendant under Rule 13G. And C, capital letter C, may assert against the plaintiff any defense that the third party plaintiff has to the plaintiff's claims, and D may also assert against the plaintiff any claim arising out of the transaction or occurrence as the subject matter of the plaintiff's claim against the third party plaintiff. Number 3 under letter A is now the plaintiff's claims against the third party defendant. The plaintiff may assert against the third party defendant any claim arising out of the transaction or occurrence that is the subject matter of the plaintiff's claim against the third party plaintiff. The third party defendant must then assert any defense under Rule 12 and any counterclaim under Rule 13A, and may assert any counterclaim under 13B or any cross-claim under 13G. Number 4, likewise under letter A, is the motion to strike, sever, or try separately. Any party may move to strike third-party claim dissevered or tried separately. Fifth, third-party defendant's claim against a non-party. The third-party defendant may proceed under this rule against a non-party who is or may be liable to a third-party defendant for all or part of the claim against it. 6, third-party complaint in rem. If it is within the Admiralty and Maritime jurisdiction, a third-party complaint may be in rem. In that event, a reference in this rule to the summons includes the warrant of arrest, and a reference to the defendant or third-party plaintiff includes one appropriate person who asserts a right under Supplemental Rule C6A, Romanet 1, in the property arrested. Letter B, when a plaintiff may bring in a third party. When a claim is asserted against a plaintiff, the plaintiff may bring in a third party if this rule would allow a defendant to do so. C is Admiralty and Maritime claim, and I'm just going to skip that. Section 1 of that section would be scope of an pleader, and 2 would be defending against a demand for judgment for the plaintiff. Now I'm not going to read Admiralty because I don't have the time, and it can't possibly be on the bar. And it'll just confuse me. So Rule 15, amended and supplemental pleadings. Amendments before trial. Amending as a matter of course. A party may amend its pleading once as a matter of course within 21 days after serving it, or if the pleading is one to which a response of pleading is required, 21 days after service of a response of pleading, or 21 days after service of a motion under Rule 12b, E, or F, whichever is earlier. Other amendments. In all other cases, a party may amend its pleading only with the opposing party's written consent or the court's leave. The court should freely give leave when justice so requires. Time to respond. Unless the court orders otherwise, any required response to an amended pleading must be made within the time remaining to respond to the original pleading or within 14 days after service of the amended pleading, whichever is later. Amendments during and after trial, based on an objection at trial. So this is Part B under Rule 15. Amendments during and after trial, based on an objection at trial. Number 1, if at trial a party objects that evidence is not within the issues raised in the pleadings, the court may permit the pleadings to be amended. The court should freely permit an amendment when doing so will aid in presenting the merits, and the objecting party fails to satisfy the court that the evidence would prejudice that party's action or defense on the merits, the court may grant or continue a continuance to enable the objecting party to meet the evidence. 2, for issues tried by consent. When an issue not raised by the pleadings is tried by the third party's express or implied consent, it must be treated in all respects as if raised in the pleadings. A party may move at any time, even after judgment, to amend the pleadings to conform them to the evidence and to raise an unpleaded issue. But failure to amend does not affect the result of the trial of that issue. Relation back of amendments. 1. This is Part C of Rule 15. This part, coming after letter B, tells me that letter B is probably not a new section, but it feels new. It feels like there's a new emphasis on this conforming to the evidence thing, like amend pleadings to conform them to the evidence. But anyway, relation back of amendments. When an amendment relates back, an amendment to a pleading relates back to the date of the original pleading when A, the law provides that applicable statute of limitations allows relation back. B, the amendment asserts a claim or defense that arose out of the conduct, transaction, or occurrence set out or attempted to be set out in the original pleading. Or C, the amendment changes the party or the naming of the party against whom the claim is asserted if Rule 15C1B is satisfied, and if within the period provided by Rule 4M for serving the summons and complaint the party to be brought in by amendment. Romanet 1 receives such notice of the action that it will not be prejudiced in defending on the merits, and 2 knew or should have known that the action would have been brought against it but for a mistake concerning the proper party's identity. Number 2, notice the United States when the United States or United States officer or agency is added to as a defendant by amendment. The notice requirements of Rule 15C1C, Romanet 1 and 2 are satisfied if during the stated period process was delivered or mailed to the United States Attorney or the United States Attorney's designee or the Attorney General of the U.S. or to the officer or agency. And I almost want to say in accordance with whatever rule I read about that not too long ago. Probably in the pleading section. So supplemental pleadings on motion and reasonable notice, the court may, on just terms, permit a party to serve a supplemental pleading, setting out any transaction, occurrence, or event that happened after the date of the pleading to supplement it. The court may permit supplementation even though the original pleading is defective in stating a claim or defense. The court may order that the opposing party plead to the supplemental pleading within a specified time. Rule 16 is the pretrial conferences scheduling management. A purpose of a pretrial conference in any action, the court may order the attorneys and any unrepresented parties to appear for one or more pretrial conferences for such purposes as expediting disposition of the actions, establishing early and continuing control so that the case will not be protracted because of lack of management, discouraging wasteful pretrial activities, improving the quality of the trial through more thorough preparation and facilitating settlement. Scheduling order, accepting categories of actions exempted by local rule. The district judge or a magistrate judge, when authorized by local rule, must issue a scheduling order. After receiving the parties' report under Rule 26F or after consulting with the parties' attorneys and any unrepresented parties at a scheduling conference. 2, time to issue. The judge must issue the scheduling order as soon as practicable, but unless the judge finds good cause for delay, the judge may issue it within the earlier of 90 days after any defendant has been served with the complaint or 60 days after any defendant has appeared. Contents of the order, required contents. The scheduling order must limit the time to join other parties, amend the pleadings, complete discovery, and file motions. Permitted contents. The scheduling order may modify the timing disclosures under Rule 26A or 26E1, modify the extent of discovery, provide for disclosure, discovery, or preservation of ESI, include any agreements the parties reach for certain claims of privilege or of protection as trial preparation material after information is produced, including agreements reached under Federal Rule of Evidence 502. Direct that before moving for an order relating to discovery, the movement must request a conference with the court, set dates for pretrial conferences and for trial, and include other appropriate matters. Modify any schedule. A schedule may be modified only for good cause and with the judge's consent. Letter C under Rule 15, pretrial conferences, again, scheduling orders is attendance and matters for consideration in a pretrial conference. Attendance, matters for consideration. D would be pretrial orders. E would be final pretrial conference and orders. F would be sanctions. All right, so going back to attendance. 1, a represented party must authorize at least one of its attorneys to make stipulations and admissions about all matters that can reasonably be anticipated for discussion at a pretrial conference. If appropriate, the court may require that a party or its representative be present to reasonably available by other means to consider possible settlement. 2, matters for consideration at any pretrial conference, the court may consider and take appropriate action on the following matters. A, formulating and simplifying the issues and eliminating frivolous claims or defenses. B, amending the pleadings if necessary or desirable. C, obtaining admissions and stipulations about facts and documents to avoid unnecessary proof and ruling in advance on the admissibility of evidence. D, avoiding unnecessary proof and cumulative evidence and limiting the use of testimony under Federal Rule of Evidence 702. E, determining the appropriateness and timing of summary adjudication under Rule 56. F, controlling and scheduling discovery, including orders affecting disclosures and discovery under Rule 26 and 29 through 37. G, identifying witnesses and documents, scheduling and filing and exchange of any pretrial briefs and setting dates for further conferences and for trial. H, referring matters to a magistrate judge or a master. I, settling the case and using special procedures to assist in resolving the dispute when authorized by statute or local rule. J, determining the form and content of the pretrial order. K, disposing of pending motions. L, adopting special procedures for managing potentially difficult or protracted actions that may involve complex issues, multiple parties, difficult legal questions, or unusual proof problems. M, ordering a separate trial under Rule 42B of a claim, counterclaim, cross-claim, third-party claim, or particular issue. N, ordering the presentation of evidence early in the trial on a manageable issue that might, on the evidence, be the basis for a judgment as a matter of law under 50A, or a judgment on partial findings under Rule 52C. O, establishing a reasonable limit on the time allowed to present evidence. And P, facilitating in other ways the just, speedy, and inexpensive disposition of the action. D, pretrial orders. After any conference under this rule, a court should issue an order reciting the action taken. The order controls the course of actions unless the court modifies it. And E, filed pretrial conference of orders. The court may hold a final pretrial conference or formulate a trial plan, including a plan to facilitate the admissions of evidence. The conference must be held as close to the start of trial as is reasonable and must be attended by at least one attorney who will conduct the trial for each party and by any unrepresented party. The court may modify the order issued after the final pretrial conference only to prevent manifest injustice. Then for the sanction section F, in general, on motion or on its own, the court may issue any just orders, including those authorized under Rule 37, if the party or its attorney A, fails to appear at a scheduling or other pretrial conference, B, is substantially unprepared to participate or does not participate in good faith in the conference, or C, fails to obey the scheduling or other pretrial order. 2, imposing fees and costs. Instead of or in addition to any other sanction, the court must order the party or its attorney or both to pay the reasonable expenses, including attorney fees, incurred because of any noncompliance with the rule, unless the noncompliance was substantially justified or other circumstances make an award of expenses unjust. Rule 17, plaintiff and defendant capacity, public officers. Real party and interest is letter A. 1. Designation in general. An action must be prosecuted in the name of a real party and interest. The following may sue in their own names without joining the person for whose benefit the action is brought, which is A, an executor, B, an administrator, C, a guardian, D, a bailee, E, a trustee of an express trust, F, a party with whom or in whose name a contract has been made for another's benefit, and G, a party authorized by statute. 2, action in the name of the United States for another's use or benefit when a federal statute so provides. An action for another's use or benefit must be brought in the name of the United States. 3, joinder of the real property and interest. The court may not dismiss an action for failure to prosecute in the name of the real party and interest until, after an objection, a reasonable time has been allowed for the real party of interest to ratify joinder be substituted in the action. After ratification, joinder, or substitution, the action proceeds as if it had been originally commenced by the real party in interest. B, capacity to sue or be sued. Capacity to sue or be sued is determined as follows. I see 1 through 3. 1, for an individual who is not acting in a representative capacity by the law of the individual's domicile. For a corporation by the law under which it was organized. And 3rd, for all the parties by the law of the state where the court is located, except that a partnership or other unincorporated association with no such capacity under the state's law may sue or be sued in its common name to enforce a substantive right existing under the U.S. Constitution or laws. And B, Title 28 of the U.S. Code, Section 754 4 and 959A govern the capacity of a receiver appointed by the U.S. court to sue or be sued in a United States court. C is minor or incompetent person with a representative. The following representatives may sue or defend on behalf of a minor and incompetent person: a general guardian, a committee, a conservator, or a like fiduciary. And without a representative, a minor or an incompetent person who does not have a duly appointed representative may sue by a friend or by a guardian ad litem. The court must appoint a guardian ad litem or issue another appropriate order to protect a minor incompetent person who is unrepresented in action. And the public officer's title and name is letter D. A public officer who sues or is sued in an official capacity may be designated by official title rather than the name, but the court may order that the officer's name be added. Rule 18, joinder of claims. Joinder of claims. A, in general, a party asserting a claim, counterclaim, cross-claim, or third-party claim may join as independent and or alternative claims as many claims as it has against the opposing party. Joinder of contingent claims. A party may join two claims even though one of them is contingent on the disposition of the other, but the court may grant relief only in accordance with the party's relative substantive rights. In particular, a plaintiff may state a claim for money, and the claim to set aside a conveyance as fraudulent as to the plaintiff without first obtaining a judgment for the money. That's kind of it for that section, which is a surprise. It's titled Joinder of Claims, so I thought it would be a little bit longer. Rule 19 is required joinder of parties. A, persons required to be joined if feasible. Required party number 1, a person who is subject to service of process and whose joinder will not deprive the court of subject matter jurisdiction must be joined as a party of A. In that person's absence, the court cannot accord complete relief among existing parties. Or B, that person claims an interest relating to the subject of the action and is so situated that disposing of the action in the person's absence may, that 1, as a practical matter, impair or impede the person's ability to protect their interest, or leave an existing party subject to a substantial risk of incurring double, multiple, or otherwise inconsistent obligations because of the interest. Joinder by court order. 2, if a person has not been joined as required, the court must order that the person be made a party. A person who refuses to join as a plaintiff may be made either a defendant or, in a proper cause, an involuntary plaintiff. In a proper case, that is. Venue, if the joined party objects to venue and the joinder would make venue improper, the court must dismiss that party. When joinder is not feasible, this is letter B now under 19, Rule 19. If a person who is required to be joined if feasible cannot be joined, the court must determine whether in equity and good conscience the action should proceed among the existing parties or should be dismissed. The factors for the court to consider include 1, the extent to which the judgment rendered in the person's absence might prejudice that person or the existing parties. 2, the extent to which prejudice could be lessened or avoided by protective provisions in the judgment shaping the relief or other measures. And 3rd, whether a judgment rendered in the person's absence would have an adequate remedy if the action were dismissed for non-joinder. And C, pleading the reasons for non-joinder. When asserting claims for relief, a party must state 1, the name, if known, of any person who is required to be joined if feasible but is not joined, and 2, the reason for not joining that person. Letter D, exception for class actions. This rule is subject to Rule 23. Rule hopefully 20, permissive joinder of parties. Persons who may join or be joined, plaintiffs. Persons may join in one action as plaintiffs if they assert any right to relief jointly, severally, or any alternative with respect to or arising out of the same transaction, occurrence, or series of transactions or occurrences, and in any question of law or fact common to all plaintiffs will arise in the action. Number two, defendants, persons, as well as vessel, cargo, and other property subject to admiralty process and rem may be joined in one action as defendants if A, the right to relief is asserted against them jointly, severally, or in the alternate with respect to or arising out of the same transaction, occurrence, or series of transactions and occurrences, and B, the question of law of fact common to all defendants will arise in the action. Now, three, extent of relief, neither a plaintiff nor a defendant need be interested in obtaining or defending against all the relief demanded. The court may grant judgment to one or more plaintiffs according to their rights and against one or more defendants according to their liabilities. Protective measures, the court may issue orders protecting or including an order for separate trials to protect the party against embarrassment, delay, expense, or other prejudice that arises from including a person against whom the party asserts no claim and who asserts no claim against the party. Rule 21, misjoinder and non-joinder of parties. Misjoinder of parties is not a ground for dismissing an action on motion of or on its own. The court may at any time on just terms add or drop a party. The court may also sever any claim against a party. Rule 22, interpleader. Grounds by a plaintiff. Persons with claims that may expose a plaintiff to double or multiple liability may be joined as defendants and required to interplead. Joinder for interpleader is proper even though A, claims of the several claimants or titles on which their claims depend lack a common origin or are adverse and independent rather than identical, or B, the plaintiff denies liability in whole or in part to any or all of the claimants. Two, by a defendant, the defendant exposed to similar liability may seek interpleader through a cross-claim or counterclaim. And B, in relation to other rules and statutes, this rule supplements and does not limit the joinder of parties allowed by Rule 20. The remedy this rule provides is in addition to and does not supersede or limit the remedy provided under Title 28 U.S.C. Section 1335, 1397, and 2361. An action under those statutes must be conducted under these rules. Interpleader. I do have limited experience with those other rules through cases that we've read. And I could go through the case section and see if I can pick them up. I just don't think I'm going to. Rule 23 is about class actions. So quickly, Part A is prerequisites. One or more members of the class may sue or be sued as representative parties on behalf of all members only if numerosity, commonality, representative parties or typicality, and typical of the claims or defenses of the class, and the representative parties will fairly and adequately protect the interests of the class. So what is meant by numerosity, commonality, and typicality? 1, the class is so numerous that joinder of the members is impracticable. 2, there are questions of law or fact common to the class. And 3, the claims or defenses of the representative parties are typical of the claims or defenses of the class. And then the representative can fairly and adequately protect the interests of the class. So when the prerequisites are met, then one of the, I think, 3 different types of class actions has to be applied. So basically, class action may be maintained if Rule 23A is satisfied and if prosecuting separate actions by or against individual class members would create a risk of. So type 1 of class action is inconsistent to avoid inconsistent or varying adjudications with respect to the individual class members that would establish incompatible standards of conduct for the party opposing the class, or adjudications with respect to individual class members that would establish incompatible standards of conduct. Okay, for that. With respect to individual class members, that as a practical matter would be dispositive of the interests of the other members, not parties to the individual adjudications, or would substantially impair or impede their ability to protect their interests. 2. The party opposing the class had acted or refused to act on grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate respecting the class as a whole. Or 3, the court finds that the questions of law or fact common to the class members predominate over any questions affecting action is superior to other available methods for fairly and effectively adjudicating the controversy. The matters pertinent to those findings include A. Class members' interest in individually controlling the prosecution or defense of separate actions. B. The extent and nature of any litigation concerning the controversy already begun by or against class members. C. The desirability or undesirability of concentrating the litigation of the claims in the particular forum. And D. The likely difficulties in managing class action. Then lastly, C, under the section certification order, notice to class members, judgment, issue, classes, and subclasses. Certification order, time to issue. At an early practicable time after a person sues or is sued as a class rep, the court must determine by order whether to certify the action as a class action, defining the class, appointing class counsel. An order that certifies a class action must define the class and the class claims, issues, or defenses, and must appoint class counsel under Rule 23G. C. Altering or amending the order. An order that grants or denies class certification may be altered or amended before final judgment. Notice for B1 or B2 classes. For any class certified under Rule 23B1 or B2, the court may direct appropriate notice to the class. And for B3 classes, for any class certified under 23B3 or upon ordering notice under 23E1 to a class proposed to be certified for purposes of settlement under Rule 23B3, the court must direct to class members the best notice that is practicable under the circumstances, including individual notice to all members who can be identified through reasonable effort. The notice may be by one or more of the following: United States mail, electronic means, or other appropriate means. The notice must clearly and concisely state in plain, easily understood language, Romanet 1, the nature of the action, Romanet 2, the definition of the class certified, Romanet 3, the class claims, issues, or defenses, Romanet 4, the class member may enter an appearance through an attorney if the member so desires. 5, that the class will exclude from the class any member who requests exclusion. 6, the time and manner for requesting exclusion. And 7, the binding effect of a class judgment on members during Rule 23C. 3, and third, judgment, whether or not favorable to the class, the judgment in the class action must A and B. A, for any class certified under Rule 23B1 or B2, include and describe those whom the court finds to be class members, and B, for any class certified under 23B3, include and specify or describe those to whom Rule 23C2 notice was directed, who have not requested exclusion, and whom the court finds to be class members. Particular issues, when appropriate, an action may be brought or maintained as a class action with respect to particular issues. Subclasses, when appropriate, a class may be divided into subclasses that are each treated as a class under this rule. Conducting the action. In general, in conducting an action under this rule, the court may issue orders that A, determine the course of proceedings or prescribe measures to prevent undue repetition or complication in presenting evidence or argument. B, require to protect class members and fairly conduct the action, giving appropriate notice to some of the class members of any step of the action, the proposed extent of the judgment, or the members' opportunity to signify whether they consider the representation fair and adequate, to intervene in class claims or defenses, or to otherwise come into the action. C. Impose conditions on the representative parties or on interveners. D. Require the pleadings be amended to eliminate allegations about representation of absent persons and that the action proceeding accordingly. Or E. Deal with some similar procedural matters. 2. Combining and amending orders. An order under Rule 23D1 may be altered or amended from time to time and may be combined with an order under Rule 16. Settlement of voluntary dismissal or compromise and notification about them, approval, identifying agreements, new opportunity to be excluded, class member objections, and appeals, class counsel, standard for appointing class counsel, attorney's fees and non-taxable costs. So the only thing I'm going to read out of those section titles is basically appeals. The Court of Appeals may permit an appeal from an order granting or denying class action certification under this rule, but not from an order under 23E1. A party must file a petition for permission to appeal with the circuit clerk within 14 days after the order is entered or within 45 days after the order is entered if any party is a U.S. agency, officer, employee sued for an act or omission occurring in connection with the duties performed on the U.S. behalf. An appeal does not stay proceedings in a district court unless the district judge or the Court of Appeals so orders. Rule 24, I hope. 23 again, about class actions. It's very short. Let's skip through it. 24 is derivative actions, prerequisites, pleading requirements, settlement, dismissal, and compromise. So letter A, prerequisites to this derivative action section. The rule applies when one or more shareholders or members of a corporation or an unincorporated association bring a derivative action to enforce a right that the corporation or association may properly assert but has failed to enforce. The derivative action may not be maintained if it appears that the plaintiff does not fairly and adequately represent the interests of the shareholders or members who are similarly situated in enforcing the right of the corporation or association. B. The pleading requirements. The complaint must be verified and must 1. Allege that the plaintiff was a shareholder or a member at the time of the transaction complained of, or that the plaintiff's share or membership later devolved on it by operation of law. 2. Allege that the action is not a collusive one to confer jurisdiction that the court would otherwise lack. And 3. State with particularity any effort by the plaintiff to obtain the desired action from the directors or comparable authority, and if necessary from the shareholders or members. And B. The reasons for not obtaining the action or not making the effort. And C. Letter C under Rule 23.1 derivative actions is settlement, dismissal, and compromise. A derivative action may be settled voluntarily, dismissed, or compromised only with the court's approval. Notice of a proposed settlement, voluntary dismissal, or compromise must be given to shareholders or members in the manner the court orders. Rule 23, actions relating to unincorporated associations. The rule applies to an action brought by or against a member of an unincorporated association as a class by naming certain members as representing parties. The action may be maintained only if it appears that those parties will fairly and adequately protect the interests of the association and its members. In conducting the action, the court may issue any appropriate orders corresponding with those of Rule 23D, and the procedure for settlement, voluntary dismissal, or compromise must correspond with the procedure in 23E. 24 is intervention as a right, permissive intervention. Notice and pleading required. So intervention is a right, letter A. On a timely motion, the court may permit anyone to intervene who, 1, is given an unconditional right to intervene by a federal statute, or 2, claims an interest relating to the property or transaction is the subject of the action and is so situated that disposing of the action may, as a practical matter, impair or impede the movement's ability to protect its interests unless existing parties adequately represent that interest. B. Permissive interventions. In general, on timely motion, the court may permit anyone to intervene who is given a conditional right to intervene by a federal statute or has a claim or defense that shares with the main action a common question of law or fact. B. A government officer or agency. On timely motion, the court may permit a federal or state governmental officer or agency to intervene if the party's claim or defense is based on a statute or executive order administered by the officer or agency, or B. Any regulation, order, requirement, or agreement issued or made under the statute or executive order. Delay or prejudice. In exercising its discretion, the court must consider whether the intervention will unduly delay or prejudice the adjudication of the original party's rights. And lastly, C. Notice and pleading required. A motion to intervene must be served on the parties and provided in Rule 5. The motion must state the grounds for intervention and be accompanied by the pleading that sets out the claim or defense for which intervention is sought. Substitution of parties. This is Rule 25. Death is letter A. Competency is letter B. Letter C is transfer of intent. Letter D is public officer's death or separation from office. I'm skipping this because I really haven't talked about it. And 26 is about discovery. So actually, I'm not skipping 25. I'm going to read this short. Actually, I'm going to walk away from that. Substitution if the claim is not extinguished. If a party dies and the claim is not extinguished, the court order may substitute the proper party. A motion for substitution may be made by any party or by the decedent's successor or representative. If a motion is not made within 90 days after service of the statement noting the death, the action by or against the decedent may be dismissed. Continuation among the remaining parties. After a party's death, if the right sought to be enforced survives only to or against the remaining parties, the action does not abate, but proceeds in favor of or against the remaining parties. The death should be noted on the record. Service and motion to substitute, together with the notice of hearing, must be served on the parties provided in Rule 5 and on non-parties provided in Rule 4. A statement noting death must be served in the same manner. Service may be made by any judicial district. Incompetency. If a party becomes incompetent, the party may on motion permit the action to be continued by or against the party's representative. The motion must be served as provided in Rule 25A3. Transfer of interest. If an interest is transferred, the action may be continued by or against the original party unless the court on motion orders the transferee to be substituted in the action or join with the original party. And the motion must be served as provided in Rule 25A3. Public officer's death or separation from office. An action does not abate when a public officer who is a party in an official capacity dies, resigns, or otherwise ceases to hold office while the action is pending. The officer's successor is automatically substituted as a party. Later proceedings should be in the substituted party's name, but any misnomer not affecting the party's substantial rights must be disregarded. The court may order substitution at any time, but the absence of an order is does not affect the substitution. So that's going to do it for tonight's recording.